All right, let's get started. So we have basically two bills on the schedule of the agenda today, but we're going to just handle Senate Bill 88 exclusively today. So let's get started. We'll start off with counsel to just give a brief description of for Josh of the bill, and then we'll walk through kind of page by page, answer questions, go through the merits, and move on from there. All right, Josh, you're up.
This bill expresses the intent of the General Assembly to maintain community trust in Maryland governmental operations and law enforcement by clarifying the parameters of state and local participation in federal immigration efforts. More specifically, it generally limits the extent to which state and local police and government can cooperate with federal immigration authorities and the extent to which those entities can share information with federal immigration authorities.
All right, so I don't know what the doorbell is, but let's keep going. It's a sign from God. All right, so we'll just start on page 2 and just walk through, and if folks have questions, chime in. If you want to
Hold questions so after you walk through and then come back?
No, let's go as we go.
We'll do questions so you walk through a piece and we ask you.
Yeah, let's do that. So I'll give a little. So on page 2, so this provides some indemnification for refusing to provide. This is indemnification for the state or local government from civil or criminal liability for refusing to create. And you correct me if I'm wrong, too, Josh. Basically, a registry based on religion, race, gender, sexual orientation, immigration status, national ethnic origin. Got it. Yeah. So, and that's carried on to page 3. And I think in the past, have passed some sort of and correct me again if I'm wrong, Josh, some iteration of this. I think even under the prior chairman, we passed a version of this, which is the basically preventing from creating a registry and then also indemnifying the local authorities from any sort of criminal or civil liability for doing so. But go ahead.
Just the next part of the bill.
Oh, just this part that I explained. Just say yes or no.
Yeah, so the chairman is correct that this first part of the bill basically provides immunity from civil or criminal liability for creating a registry which discriminates on certain grounds and also allows for indemnification of individual state officials.
So I guess this first question is a registry. Do we have a definition of registry? I mean, to me, registry is something I register for. So is a registry in here mean a list?
No,
you register in a registry, which would suggest that I register in a registry. So is registry just synonymous for a list, or?
I think it's like a list or a database that is maintained on the basis of religion, race, gender or sexual orientation, immigration status, national ethnic origin. So, yes, a list or any sort of a database that would be maintained by the state or local government.
So what would happen if that list is created for the purpose of public safety? It's not created for the purpose of discriminating. The purpose is public safety. And if a legitimate public safety interest would include identifying people who are A, in the country unlawfully, and B, might have some involvement in criminal elements. Is that a database created for the purpose of discriminating, or is that a legitimate database creating for the purposes of enhancing public safety?
I think in that instance, and it would be public safety, but then the key phrase here is on the basis of religion, race. So immigration status could clearly fall into the hypothetical that you referred to, or even national ethnic origin could potentially. But this is on the basis of these 4 protected classes, and then you add in immigration, then you add in national or ethnic origin. So this isn't for the maintenance of basically public safety. It's just on the basis of those identifying criteria or those identifiers.
Right, but would a public official have to say, with such an impermissible registry, would that say, we have a registry, a database over here, and the purpose of you putting people in this database is because we don't like Jewish people, or Muslim people, or Christian people, or we don't like black people, or Asian people, or white people? Would it have to be that? Because, or, I mean, clearly, a registry for, a database that says up front, we're here to be biased against people. I think you have total agreement, unanimous, throughout the entire General Assembly, that any such registry would be grossly inappropriate, not to mention unconstitutional and immoral. But if something has, if you're creating a registry for public safety or a database for public safety, and you want to track people effectively, and you would say, well, if you put me in there, you say Robert Castley from Maryland and all those things. But if I was tracking someone from outside of the U.S., I would say this person's name from Guatemala or whatever, and put that in there. But that's that would include their national origin. And so, could you not participate or feed data into it? My problem is I'm a public official, and now I have to say, well, what is the purpose of your, I'm giving you information that has all this stuff on it. I mean, clearly my race, my gender, we keep those in our driver's license. So, and that's apparently okay. But now as a public official, I have to say, okay, I'm feeding data into here. Is this for purposes of discriminating? And I mean, we discriminate every day, constantly, and it's not necessarily a bad thing if we have the restrooms and people walking in the restrooms and the like. So it just seems to me that this is very vague to say that it's a maintenance for the purpose of discriminating, because A, I have to say, is that the purpose? And B, is that an inappropriate discrimination? Because it just seems like we'd be so common that we would have, databases like this that would indicate, this kind of information. So I don't know how we could possibly, because what you almost may be saying is that not for the purpose of discriminating, it's, if it would have to say right up front, we're creating this database because we don't like people of this kind, and we want to discriminate against them. But I suspect that the intent here is maybe not for the purpose, but well, I don't know what the intent here is, because no one's going to create a database that says this registration is because we don't like people of X demographic mix. So if that's where we are, then it seems totally a useless piece. And if it's not where we are, then what does it really mean?
Senator Jackson, and then I'll respond.
Thank you, Mr. Chairman. So, from my perspective, I remember, as we've seen in the public safety world, where 287G was put back to the Department of Corrections level versus the policing level, law enforcement level. I happened to be the president of the Maryland Sheriffs at the time when then Sheriff Hagee from Frederick brought it before the Maryland Sheriffs Association to try to get everyone on board. So I remember that context, but I also remember the context of being a street deputy working in the fugitive warrant unit, in the height of the crack epidemic, and we started identifying people from New York and other places, Philadelphia and other places, but then that led us to Jamaica, that led us to other places, and so our identification of those folks is based simply upon the public safety aspect of what we were doing. So, and you can go back well before my time, and if you're talking about folks that are involved in certain criminal activities, they may have been a part of they may have been Jewish, they may have been Italian, they may have been whatever. I think I know where we're trying to go here, but I think this is a little bit restrictive, and I think maybe, I don't know if wordsmithing by our analysts could help us out with this, because I think you can't put people in a protective class when, from a public safety perspective, we need to know any and everybody that we come into contact with. And if that means to say that, I'm from, I'm here, whether I've overstayed my visa, I'm a college student who just said I'm not going back home, or I'm here for the summer in Ocean City, and, and all of a sudden I'm not going back, or, I came across the border somewhere, and I just think we need to be very careful not to exclude an investigatory tool that not only public safety, but our government as a whole. I think we need to be very careful not to restrict our ability to know who we're dealing with. I think, and lastly, I'll say this: part of the 287G piece was, from the law enforcement side, it began to not make we came to grips that meant that you cannot enforce that, because it would put the officer and the public in some grave danger, because you don't even know who you're dealing with. And if I'm restricted on trying to identify a person that has no identification on them, or that identification looks a little sketchy, then you really can't be restricted on asking those sort of questions. I think we have to make sure that, from an accountability standpoint, that folks aren't going overboard with it. But I think we can't be so prescriptive to say you cannot ask these questions, because there's a public safety danger, not only from injury perspective, but also from the things that we need to establish. So I'd be interested in looking at some additional language versus this. Thank you.
Question is, where was this pulled from? Because I'm sure there are other jurisdictions that do similar things, and so was it pulled from one of those other places, or?
I'm actually not sure about that. I mean, I think a lot of the conversation, remember, the history of the bill spanned even back from just like the kind of the Muslim registry. Do you remember like those conversations that were? And so I think that was kind of the genesis of the idea, of just making sure they weren't maintaining a database for the express purpose of collecting and then discriminating against on the basis of these attributes. And so, definitely hear what Senator Jackson and Senator Carter, and then also obviously Senator Cassidy are saying. But that's the general idea. And like I said, I don't think anyone in the entire general assembly is against that general idea. But I hear what you're saying, Senator Huff.
My problem with the bill is that this bill's been around for a while. I mean, this is the infamous sanctuary bill that it's not. We're on Senate Bill 88, right? Okay, well, this is the bill that says they have to ignore detainers, correct? That says that because the detainers are from Department of Homeland Security are civil in nature, they must ignore them, correct?
No, we're going to walk through the bill kind of page by page, but
I mean, that's the crux.
Yeah, that's the crux of it. I mean,
that's the crux of the problem.
That's the crux of the idea, so that we wouldn't run. There's some Fourth Amendment issues and 10th Amendment issues and we'll get into it. But yes, that's the crux of the idea. The civil detainer cannot be used to hold someone, and then also the bill prevents that level of cooperation. So. With the federal government.
I mean, the databases or whatever, I mean, the main controversial part of the bill, and actually I'd be interested what Senator Jackson, if he knows, because Prince George's County had a policy similar to this, and that they were ignoring detainers from Department of Homeland Security. And I believe that they ended up changing their policy, especially with individuals that came in or had violent crimes and then got detainers, because what happened was they ignored a detainer request from Department of Homeland Security. They released 2 individuals. Those 2 individuals went out and promptly beat to death a 14-year-old little girl. And so because of that, Prince George's County actually had to change their policy. And my understanding from the Department of Homeland Security, I don't know what form the Biden administration's using, but if they go back to use the form from the Obama administration, ICE issues a detainer for the following reasons. 1, the person has engaged in suspected terrorism or espionage. 2, has been convicted of offense which the element was an active participant in a criminal street gang. 3, has been convicted of offense as a felony other than state local. 4, has been convicted of aggravated felony. 5, has a significant misdemeanor. And the last one has been convicted of misdemeanors not including traffic offenses, state or local offenses, which immigration status was an essential element. Probable cause exists. The person has a final order of removal, and so on and so forth. So the main elements that they're issuing these detainers, if the Biden administration is going to use the same form that the Obama administration used, these are all serious offenses. It's terrorism, street gangs, human trafficking. This is all bad stuff. They issue that detainer, and under this bill, and for the Police and Sheriff's Association, this bill would prohibit a law enforcement agency from transferring an individual to federal immigration authorities, detaining an individual, notifying federal immigration authorities of an individual's release date, location, or address, or use law enforcement resources to further civil immigration enforcement without a federal judicial warrant. If we do that, we can just look at Prince George's County to see what happened. There was a 14-year-old girl that was beat to death and died, and that would not have happened had Prince George's County not had that sanctuary policy in place. So that is my main overriding problem with this, is this has us ignore federal Department of Homeland Security detainers. And just so everyone knows, if you come into this country illegally, Department of Homeland Security does not know. They only know if you're in their database if you've done something bad. So some of these people may have just skipped out on they were given court hearings, they skipped out, they didn't show up, which that's a problem. They're ignoring bench warrants. But all these people have done really bad things. And if you look at, and is there any carve-out whatsoever on this bill to reflect what the prior federal form said, to reflect what Prince George's County did with violent offenses?
With the form, so I want to make sure we get to everyone who's got their light lit up, but I want to go back and then do kind of go through the bill top to top, like line by line from start to finish, so we get to some of those issues that Senator Huff brought up. But I'll just say first, I mean, when you get into about halfway through the bill, so a lot of this deals, the crux of the bill is the civil piece, not the criminal. So nothing would prevent the state or locals from cooperating with or any sort of underlying criminal investigation or criminal records. So that's, something we need to talk about. We'll get into that. The criminal piece there is separate and apart from the civil. I think we should make sure to keep those two spheres properly in their place when we have the discussion. And then with respect to the kind of the illegal crossings, which is a criminal act, but obviously unlawful presence is civil, most of the folks, and I will get this data for our next duration discussion, the folks that fall under this kind of unlawful presence umbrella are folks that are from overstays, like visa overstays. And so we'll talk more about that as well, but I want to make sure we get those facts straight. But let's go to Senator Bailey and then Senator Jackson.
So I do have some concerns. I think Senator Jackson and I are probably the only two in here that's really worked with customs before it transitioned into ICE, but actually was involved in it. And I think that there's something that when we talk about this, there's a reality right here in Maryland that we need to be aware of, right? We all remember the 9/11 and the World Trade Center bombing. But what the reality is, before that, it was bombed before the successful, and the terrorist cell that earned the money to finance that bombing was done here in Maryland. It was done in Virginia. It was done in Maryland. They earned the money here in our communities. They were illegal aliens that did that. There were things, I worked on a case in Pocomoke where it was after 9/11. One of the largest terror cells that was located in the United States was in Maryland. We found out and worked that through ICE. that we have no idea the devastation and the amount of money that we took from them of how that would have been a domestic terrorism issue for us. I know working in Ocean City, because there's a lot of visa stays that are overstayed there in Ocean City. There's a lot of illegal things that are sold to the millions of dollars every day on the boardwalk. But the fact is, when we were working down there and all of a sudden we started seeing people coming up with valid Virginia driver's licenses that we knew shouldn't have been there. And so we did some purchases, and we finally located the machine. And if you remember, there was an MVA, or not MVA, it was a Department of Transportation Virginia office where they drove the the big truck into the building, and they took all the computers and they took all the printers, and there they were right outside Ocean City, Maryland. Set up in a house in a basement, and here we were printing Virginia driver's licenses to these people. And when we got there, the line was out the door, of people trying to get illegal identification, state identification that were there. I think that there are any number of examples that we can bring up that there is complete concern on the behalf of the citizens of Maryland that people that are here without the proper identification pose a risk to the general public and the people that are here legally. And I think it is much more significant than just saying, well, we've got to look out for their rights too, because we have to look out for the people that are here. And the thing is, the way that we find out about this is through interaction with these people. And I think that, knowledge clearly is power. And we want to make sure that we regulate that. But we don't want to say we can't have it. Because in those situations, if we had a policy like this, then we didn't work hand in hand with them in Maryland, I think that there could have been some issues that would have potentially affected any one of us or our families here in this state. And I think that that is of significance that we need to talk about. And I'll just ask some additional as we move into the bill.
Yeah, Mr. Chairman, I just want to sort of address something Senator Huff said earlier. And while legitimate on its surface, there's also some backdrop to some of the things that have occurred. So I think because of the inconsistencies that we've dealt with our immigrant concerns in our country and our local jurisdictions, has led to some challenges. I know, again, I worked in the unit that, we held detainers on folks all the time. But there came a time in law enforcement where you couldn't just pick up the phone and say, hey, it's Mike Jackson from Prince George's County. You got a guy over in Northern Virginia. We think he may be such and such. Can you hold him a few more days for me while we're working on something? You cannot do that. And so then it went to, you need to have a judicial warrant. You need to have a document that was a legitimate document before you can hold someone after their release date or pending release. So for one, we need continuity. For two, we need not be so restrictive that we can't ensure the public safety. And so there are enough lessons learned, if we're really going to pursue this, to pursue it properly. I am, our challenging, multicultural, diverse country has a lot of issues, I do not want to be a part of creating an additional issue. We just need to figure out how we get to the point where we remain as safe as possible, but that we do not restrict the people who have the charge given to them by us on what to do, and at the same time not putting people into harm's way unintentionally. The whole creation of the Department of Homeland Security was a mess. It came about. It was a knee. Not. It was well. Some folks may believe it was a knee-jerk reaction, but the evolution of that department caused a lot of challenges, particularly for those who worked with them, partnered with them from the local agencies. We were used to dealing with individual agencies. We had those relationships. And so it caused some challenges. Not an excuse, it's reality. We need to address the concerns that we have in our country and our state. And but I would just caution us all, including myself, as we move forward, to make sure that we're putting forth some policies that are sustainable and that are applicable to tomorrow and not just for today, because today's notion is not going to be good enough, probably not even for this afternoon or tomorrow. So that's just my little editorial on that piece. It's true and tried, and I just, glad we're having this conversation today.
No, I appreciate it. I've worked at DHS, the largest governmental reorganization since World War II. 22 components slid under one roof. It's tough. Okay, Senator Castley.
General, my first question was really on a specific piece of the bill, but I think if people are making sort of generalized, broad statements, as we're going through this bill and others like it, I think it's, we talk, does our country have issues? I think our country has challenges. Believe that our country is the most fair and open, law-abiding country that the world has ever known, and retains that we're the land of opportunity, and that when we saw the Asian women gunned down, I guess I lose track of time, earlier this week or last week, I lose track of time when things occur. We took that as a national tragedy. But let's face it, every Asian woman pretty much in America has more rights, more freedoms than 1 billion or 500 million, whatever, Asian women do in China. So we have challenges. There's always challenges in whatever you do. But I think that we have to just move forward, keeping in mind that we try to do the right thing. The world throws lots of challenges our way. But we have to also be careful that in our zeal to be fair to everyone, and that's a good thing, it's a good zeal to have, that we don't do serious damage to the basic legal structure of our society, and that's important, that we do provide those protections. And I don't know how anyone could possibly dispute that when you when you look at how policing works throughout this country, where oftentimes we find evidence or roll people up for serious violations simply because they were pulled over for a traffic infraction, or some other much more minor thing, but it's where the police finally look at that individual and say, wait, this doesn't make sense, and then they stumble it back and find out that you've got a really bad individual there, and that's totally appropriate. But to make that work, if the cop rolls me up, they can very quickly, using their computers, find everything about me, my entire life, and know every detail. So if I try to BS them for 1 second, it's all laid out there. Civil histories, criminal histories, family histories, financial histories, it's all right there. But if I've got somebody who's nefarious, who comes in from south of the border or north of the border or east or west of the border, who comes in, the police have none of that information. That person has a distinct advantage over me if they have a desire to commit criminal acts. They have a distinct advantage because you don't know they can tell you all kind of stuff that you can't possibly prove or disprove, and they can come back and forth across the border without, their structure is south of the border, their support element may be south of the border or north of the border. They come across the border, carry out criminal activity here, they're gone. I can't do that. If you're based in the U.S., you're easy to capture. So that creates a distinct, serious problem for law enforcement, where you have this element that can basically base itself out of another country, swoop in here, engage in criminal activity, and then be gone. So you and come and go rather quickly. That's alarming, and it's certainly associated with a fair amount of the crime that we're seeing here, particularly these horrible crimes. Really brutal, the brutal nature of the crimes. So as we go through these bills, I think it's important to just kind of keep perspective on all these things and not say, oh, well, we've got to rein in this evil society of ours, because I don't think that's true at all. Thank you.
Excellent. We'll continue on. I mean, I think, I don't want to make more global statements of the purpose of the bill, but obviously we've got a very robust immigrant population, and we don't have necessarily an immigration problem. It's the problem, if there is one, is that people want to come here because of what you did say is true. This is I think the most open and broad democratic government on the face of the earth, and the real premise of the bill is to ensure that the folks that are here, feel comfortable interacting with law enforcement and feel comfortable engaging with our institutions without fear of, targeting and abusive treatment based on their status. So I think we all have the same goals. We all recognize that this is the greatest country on earth. We all recognize people want to come here, people want to be here, be a part of this, and want to contribute here. But so let's keep moving on. Yeah, we'll go with the specifics, and then
The crux of what your entire position there, Mr. Chairman, is on page 4, the next section we'll be getting to, which says a law enforcement agent may not, during a performance of irregular police functions, inquiring about an individual's citizenship, immigration status, or place of birth during a stop, search, or an arrest. So I think you'd have a lot of agreement within this body that on a stop, probably won't get any fight on that one. A search, assuming the search refers to a stop and frisk kind of a search, not a search warrant search, but a stop and frisk, again, probably not getting any disagreement. Then we have the arrest. Now all of a sudden it's like, well, wait a second. So now they're in the detention center. So that's where we start drawing these lines. So where is that balance? I think that balance, the issue you raise is the most clearly before us in those two lines. How far does this go? How far do we tell police, don't be on an immigration enforcement sweeps here, don't be doing that, versus at some point, when does this become important for public safety? And I think that's the nub of what this is all about. Our discussions really come down to that point right there. Where do we draw that line?
Yeah, it's funny you honed in on. I was talking to counsel about this bill before the session, and we got exactly right to page 4, going down, and we talked about just, okay, we get it, like no show me your papers. Everyone, I would hope that everyone can read that. Then you get to the nuance of what an arrest means. You're talking about kind of the custodial arrest. You're talking about arrest on the side of on the side of the street. You're in the back of a squad car. You on the street corner, or are you actually being processed into booking? And that's where the conversation. That's where the real meat of this conversation needs to happen. So keep going on with. I've got Senator Bailey, and then unless Senator Bailey, and we'll keep going. And then I want to toss it off to counsel.
So I think I think this is an appropriate time to talk about exactly what we just brought up, and that is that if I go back to the hearing, I think we actually talked about somebody cutting a tree.
Yeah, I believe that incident actually happened in my district, or definitely in my county.
I'm going to go to the criminal law, talking about a police officer when they stop a person for violating any law punishable that's a misdemeanor. The officer may prepare a written or electronic citation containing the notice to appear in court, the name and address of the person charged, any relevant license numbers, and the person and the time and place the person shall appear in court. The acknowledgement of the receipt of the citation by the person charged, made in any manner determined by the department, and other pertinent information required by secretary. The acknowledgement of receipt of a citation, the person charged may promise to appear in court by acknowledged receipt of the citation prepared by the officer in a manner determined by the department. If the person charged acknowledged receipt of the citation, the officer is not required to take the person into physical custody for the violation unless, and this is where the whole thing with this law becomes problematic. The person charged does not furnish satisfactory evidence of identity. There is no exception for that officer. If you have committed something, even in the example in the hearing, as cutting a tree, that is a criminal violation, is a misdemeanor, that office, if you do not have satisfactory form of identification, then you have to be arrested. You are then taken to district court commissioner. So that is the law. There is no ability for an officer in the state of Maryland to overlook that. So we really run into a brick wall when we're talking about this, saying because all of a sudden now we're going to incarcerate this person for committing a violation. And that violation could be a traffic offense. It could be a boating offense. It could be any situation that you might run into as a law enforcement officer. Somebody cutting a tree on the side of the road, somebody throwing trash out of a vehicle. Any scenario like that, you're going to end up incarcerating that person. And so that's when, just wanted to bring that to the attention, because that is, to my opinion, that creates really a problematic issue with this.
Right. So the distinction there, though, is there, so during the initial interaction, the inquiry is not appropriate. I mean, let's say you're talking about when they're actually getting booked, and that's where I know this is where the conversation's heading, but that initial interaction when someone's on the street or whatever, I mean, they were all, agree that the inquiry is not necessarily relevant to anything. Yeah, that's the Arizona case. So it's based on the governor of the "Show Me Your Papers" piece. Okay. But I guess I was trying to figure out.
It's not just a random, right? They have committed some crime. And when that person has committed a crime, at that point in time, they have to prove some form of identity, right? Or they are arrested. At that point, and that's what's going to happen.
On page 4, subsection B is an expression of the intent of the General Assembly. Subsection C is largely the provisions that were just being discussed. So a law enforcement agent may not, during the performance of regular police functions, inquire about the person's citizenship, immigration status, or place of birth during the stop, search, or arrest, detain or prolong the detention of an individual for the purpose of investigating their immigration status, or based on the suspicion of committing a civil immigration violation, or transfer the individual to federal immigration authorities unless required by federal law.
This is the piece where critics, and I would say it is the sanctuary policy piece on this exact page. This is the piece that says the state of Maryland will not cooperate at all with federal immigration. They won't even tell you when they release these people where they're going. And so I actually did a bill after the issue in Prince George's County. Prince George's County changed their policy to say essentially that upon 72 hours before the release, if there had been a detainer and the person had been convicted or charged with a 14101 crime of violence, a Title IX, Title IX, which is sex offense, that they would then turn the person over. So this doesn't even have that carve out that Prince George's and some other counties put in place because of horrific murders that happen in their areas.
So my question is, so you've taken this person now, you're at the detention center. And if you're not going to find out where they came from, and you're not going to call immigration, what do you do with them? Right? I mean, because you're not just going to let them go, right? Because the officer couldn't quite let them go when he first caught them. And so now we've got a situation that if they had identification, clearly we can let them go on their own personal recognizance, especially for a minor issue. But we have to somehow, have some identity for these people to be able, and that is the whole thing of dealing with. Now it's HSI instead of just ICE, but HSI, they're willing and able to assist with these types of situations. If they have identity, and it doesn't have to be a driver's license. It can be personal identification that they have that is their true identity, as long as the commissioner feels that they do at that point in time make a concerted effort to come back for court, they can be released. But it's not a situation that you just can, all of a sudden we're going to say, well, you committed the same crime that a person that is a legal citizen did, but we're going to let you go, and the legal citizen is going to have to pay a different penalty.
No, I hear what you're saying. Obviously, if you're there, you're going to be, I mean, for whatever underlying offense you're there for, but you're right, for the less offensive, for the ones you'd be released on your own recognizance. The bill we'll talk a little bit later on about the acceptable forms of identification that the bill has. But, sorry, go ahead.
So do you see an amendment to allow, Senator Huff talked about this Prince George's County. I mean, to just say, well, a release is a release is a release seems sort of just naive to suggest that I'm releasing you for a crime. You've been put on, the court released you on bail for a crime of violence or for a sexual offense, and the court wouldn't know that you didn't have ID. It's not going to be before the court. The court will just know that you gave an address of Rockville and you're from Rockville, and that's all that's going to come. Versus the court would not know that this person was actually had a federal detainer, for immigration issues and suspected of bad stuff. That wouldn't be before the court because no one was able to ask or relate that stuff. So, I mean, at some point we're going to end up with, and we've seen how this has come out with little girls that are raped or stabbed 27 times and have their heads cut off, and because these are really, really bad dudes that are coming in, so to screen this out. Do you see some kind of an amendment to at least parse out the difference between somebody released because they, didn't have their driver's license or expired tags or something versus somebody who's, those sort of things?
Obviously, you want to capture the folks that are dangerous, but and what we don't want to do is ensnare kind of the other, 99.9%. But Counsel, remind, and I don't know if you know the answer to this one too, but the Montgomery County and Prince George, I thought Prince George's County reevaluated their situation, and I'm not sure. I mean, I'm not. If we could get some clarity, I'll let Senator Huff go first, and then we'll get some clarity on what Montgomery and Prince George's have done in recent months and years. Senator Huff.
Yeah, it's just because my understanding, I'm looking at Article 2, it wasn't just Prince George's that reversed this policy. Montgomery County did as well. Montgomery County had, over the summer of 2019, a number of individuals they released who went back out and started sexually molesting children. And so Montgomery County, in the summer of 2019, 3 months after Montgomery County executive banned U.S. Immigration and Customs Enforcement from accessing secure portions of the county jail, the Eldridge administration has quietly reversed the policy. This is from ABC 7. Effective immediately, Montgomery County correctional officers have been instructed to grant ICE clearance to identified areas of the jail to ensure that transfers are conducted in a safe environment. That level of cooperation mandates that ICE submit an immigration detainer and arrive at the jail along 7 Locks Road in Rockville prior to the defendant's scheduled release time. So they're not doing like this bill, says 72 hours, just let them out. And they did it for good reason. I mean, there's a whole list here on ABC 7 about all the suspects that summer that they released prior to this policy, prior to changing it, that they were ignoring detainers, and these individuals walked out, and they sexually molested, let's see, here's one. He sexually molested his 9-year-old stepdaughter, and there was a handful of these, of sexual assaults in the county that were all directly tied to the ignoring of detainers. So even Mark Elrich, who's about as far left as you can get in the state, had this policy and he reversed it. So I don't understand. We have in Prince George's and Montgomery, which are, two of the most progressive, had this policy and they reversed it because people got raped and killed, little kids.
All right, you want to, if not, we'll get more clarity on that if you want. Okay, great. All right. Look, we've reached the top of the hour here. We're about halfway through. I want to focus in on the subpoena piece, the warrant piece, in pages 5, 6, 7, 8. But we're going to stop here right now because we've got some police reform work groups that are coming back. So we've got in the next couple days, we essentially have to get police reform. So we're just over crossover here, and we need to make sure that package is worked out. The committee's got to take a look at the product. We've got to get something back over, for consideration for a conference committee and on the floor by sometime early next week. So there's a lot of work to be done. So let's do this. We'll cut shop here. Members can focus in on the police reform issue ahead of us, and then we'll come back to this. We're halfway through this bill, and we'll continue to debate, and we'll move forward from there. So today's Tuesday, right? So tomorrow's Wednesday. We'll come back. We'll do the same thing, and continue our work. So sorry, go ahead. What time do we have floor tomorrow?
10:30.
So we have floor at 10:30. We got a gap there, and then we've got. I think this committee signed up for sexual harassment training from 3 to 5 tomorrow. So we've all got to be on camera the entire time. So we'll squeeze in some time to do some voting and debate after floor and before the training. All right. All right. We'll continue the work for the rest of the day, and I'll see you guys soon. All right.